All this is preceded by a violation of law in the sense that there is non-payment or insufficient payment. Therefore, all this is to be brushed aside, pushed under the carpet, and then send it to the arbitrator. Formulas, that's why I put it in the first instance. Your Lordship's order, sending a document to a collector, or the High Court's order, sending it to a collector means for valuation, assuming that 35A proviso is not gone through. The collector, my lords, would do everything to get it done within 45 days or any other limit that your Lordship put it. Is the same, my lords, to be expected from an arbitrator? If an arbitrator writes to the collector, I'm only, my lords, assuming if we are now on a practical aspect, working aspect of it.
Post-reference the arbitrator himself can do it. He's not supposed to refer the matter to collector.
Same thing for the court. The same thing for the court. The collector comes in, that's why I'm saying 35 and 38. 35 and 38. 35 is...
Normally the person who comes with a request for reference, he would be keen to have...
But that's why. May I just place it that way? Because if you look at section 45 and 44, they say you pay. Even if it is not your liability, you pay. You can adjust it or put it in your claim, in your suit or arbitration or whatever it is. Number one. Number two, if you have any qualms about it, 45 permits you to make an application to the Chief Revenue Controlling Authority for refund of duty and penalty. So any person, any applicant who is eager to initiate the arbitration process, he will just say, okay, according to me, 10 rupees is payable. According to you, 100 rupees. I will pay 100 rupees. Let us go on with the arbitration. Let us go on with the arbitration. And the differential amount, 90 rupees, I will put it as costs in my claim because the section permits it. The section 44 permits this. 44 of the Stamp Act. 29 is very clear who is responsible to pay stamp duty, subject to an agreement between the parties. If divorce that, you come ahead and pay, you can claim it.
The problem is slightly different.
Yes.
If there is a clause of arbitration in the contract,
Yes.
standalone agreement, what is it? 10 rupees, 5 rupees, annas are there.
Yes.
Annas we convert into rupee, now come to 5 rupees, whatever. 10 times penalty, maybe 50 rupees. No problem to it. What is happening is, practically, the ground reality is, courts are not able to proceed because the clause of arbitration in the contract, until the contract agreement itself is not being adequately stamped, and the valuation takes time of the contract. That's why the courts are not proceeding to initiate a case.
Mind and a legally trained mind of a judge to do it, rather than leave it to an arbitrator. And again, the issue will arise.
But this line of argument, we can't be overlooking what is the objective of this enactment. Yes. We have borrowed the Uncentral model,
yes, please,
which speaks about an efficient arbitration proceedings.
Yes, please.
Now, if we are going to put spanners at the stage of Section 11 exercise of power,
no,
then are we actually looking at an efficient arbitral proceedings?
Put it a bit differently. Are we, Millers, going to follow Uncentral model to an extent that we breach our own laws?
No, we are not talking about breaching our own laws. What your argument is in the context of the Stamp Act, yes, which requires you to levy the stamp payable, right? So are we breaching the Stamp Act? It is inadmissible. That is the bar under the Stamp Act.
Plus, not
no, correct. And the examination is also Section 16, as my brother Rastogi has pointed yes, out. Section 16 scrutiny post-appointment is also available. So therefore, don't put it at a level that are we overlooking our own law. It is not like that. How can you be saying you are overlooking our own?
In my submission, the statute creates a bar
on admissibility. Evidence.
Step forward. The statute creates a bar on whom. It applies to the court, it applies to the arbitrator. There is a judgment by my Lord Justice Rastogi, who was a party, that Ganga Appa, that there is nothing in the legislative scheme of the Stamp Act to show that it would not apply to courts, or it is applicable only to the arbitrators. Number one. Number two, there is a judgment of this Honorable Court saying 33 provides impounding. Impounding is mandatory. With these concepts coming in, impounding becoming mandatory. And then
saying... There also you just again see Section 33.
33.
of the Stamp Act,
Yes, please.
it says several, that is officer, the authority, etc.,
Yes.
before whom any instrument is produced.
Yes, please.
Except a
Now,
except a police officer.
acceptable.
Yes.
Now, consider this thing. As long as this Stamp Act is made applicable to the proceedings under the Arbitration Act, and then take note of the fact that there are two proceedings or two ways to reach up to the stage of a 16. Because parties make one consent without the intervention of court, go there before the arbitrator, or for appointment they may approach a court.
By consent of Section 11.
So, be it under Section 11 or directly by the consent of the parties, question is whether once it is produced before a court or before the arbitrator, at the first instance itself, the impounding should take place or not.
Yes. According to the respective submissions, yes.
It should take you because 35 says otherwise it is inadmissible and therefore it cannot be acted upon or enforced. It cannot be enforced. So the contention is that whatever the way, once it is produced, be it before the arbitrator or before the court, in terms of Section 33, impounding should take place.
It is the mandatory.
That is, you have some answer. So it appears that that is your.
That is.
So merely because it is produced at the stage of 11 or parties are approaching the court, the court need not relegate the parties to after appointing the arbitrator. It can on its own.
Yes.
That is the condition.
That is my submission. That is my submission.
Then
And
that will take you back to a fundamental question,
Yes.
which is Section 33.
Yes, please.
That's the first two lines.
Yes, please.
Every person having by law or consent of parties authority to receive evidence. Now, when a court, be it the High Court or the Supreme Court in a domestic or an international arbitration, deals with an application to the Section 11, is it an authority having by law or consent of parties authority to receive evidence? Is evidence being received when you deal with an application to Section 11? Because that is the crucial condition precedent to apply Section 33, as also perhaps Section 35, because they are acting upon is also there. But otherwise, will you say that the court is receiving evidence in Section 11?
Yes.
We just want to know because
Yes.
it's crucial to it. Because once it is authority to receive evidence, then perhaps it is inevitable that you have to necessarily impound the document.
Evidence is followed by a comma. Evidence is followed by a comma. So it's a complete sentence, if I may say so.
Yes.
Every person having by law or consent of the parties authority to receive evidence, comma.
It is the authority to receive it.
So first class. And every person in charge of a public office, second class.
That's right. If you're going to say that the court is comprehended within the expression
First
of
expression.
charge of a public office.
No.
No.
The first one. The first one.
So authority to receive evidence. So authority to receive evidence in the context of Section 11, does the court ordinarily or is the court expected to receive evidence?
That's evidence was of in my submission, approaching it only restricted to 11.6a. It can only be 8, also 8, 9, 11.6a. Now, 11.6a in the sense what? It is evidence of what? It is an evidence because that there is an arbitration agreement. So please refer the parties to arbitration and appoint an arbitrator. Evidence of what? Evidence of an arbitration agreement.
That's right.
And requiring appointment of an arbitrator.
Does it boil down to receiving evidence?
We are receiving evidence,
Is it
the instrument as evidence.
because you don't use
No,
oral evidence?
I understand. It's not the trial court and the criminal court.
It is, but it is evidence still through the affidavit, I take it. That you're producing, because it normally, for example, in Article 220.
Yes.
What is evidence? The evidence is the affidavit evidence.
Affidavit evidence.
That is evidence action.
Yes, please.
Can call the other side for cross-examination. If you file an affidavit,
Yes,
in an approved case, it has been done in Kerala High Court, where you've taken evidence in oral evidence, of course, we have taken. But we just this has to be
Yes,
just
my
dealt with by you.
Huh.
We wanted to
Yes, according
just
to
get the stand back commentary. Stand back commentary.
This is Maharashtra stamp.
Any decision under section 11 as such, I mean under 33, I mean under the Arbitration Act, 33, under 33 connected with the
because 33, I can show Milos 2019 volume 3 SCC 788. But I'm sorry, but that's not in the compiler. 2019 volume 3 SCC 788.
What does it say? 2019.
19 volume 3 SCC, page 788. This is my lord, this is Ashok Bhushan and my lord, this is Rastogi. I'll just read the relevant para.
Which is the para?
What's para 14?
गलत जजमेंट आपके साथ जज के लिपाट और आवेदन करवाते हैं
Was Matt first raised the issue as to whether the penalty which was provided in 35 is negotiable. The court says no. Your Lordships, I have 2019 volume 3 SSC. Straight, please come to para number 14 at page 793. Last about,
You read it, I'll follow.
yes, ma'am. Last about 7 lines. Section 33 applies to every person having by law or consent of the parties authority to receive evidence and every person in charge of a public office. Thus, Section 33 covers a host of authorities, persons before whom instruments are filed. The legislative scheme does not indicate any distinction between a court receiving an insufficiently stamped instrument in evidence and other authorities. All have to impose penalty of 10 times of the duty for deficit portion if it exceeds ₹5. This provision is for the purpose of maintaining a uniformity in imposing a fixed penalty of 10 times without adverting to any adjudicatory process regarding quantifying the quantum of penalty. The statute gives discretion to the Deputy Commissioner, who is the authority envisaged by the Act in charge of the revenue administration of a district. Then it is the discretion only of the revenue officer. Once the penalty is provided by the statute, it has to be imposed, and all the section 33 would apply also to courts. That's why I'm relying on.
So this can be this section 13. If you are reading it and splitting it, no, this view virtually, no, this is correct because first, see, every person having by law authority to receive evidence. Second thing, every person by consent of parties authority to receive evidence. To
Arbitrators.
and so they are not only the authorities who are there. Next one, and every person in charge of a public office. Then exceptions, before whom any instrument or chargeable in his opinion with a duty. So all these question is before any of these categories. If it is produced, then they can impound in way of a section 30.
They have to impound. They have to impound.
They need not or they cannot now relegate it to a they are bound to that.
See, there are two ways of looking at it. When you read section 33, it says, having authority, every person having by law or consent of parties authority to receive evidence. Stop there. Now, the fact that it was taken a judge of the High Court is very clear from the proviso, because it enables him
Delegate.
there also can be, we can bear in mind that certain high courts have original jurisdiction.
Yes, Bombay.
Bombay has,
Bombay.
Calcutta has. So it could perhaps be, so we come back again to the opening words of section 33, and it's perhaps susceptible to two interpretations. Firstly, every person having by law or consent of party authority to receive evidence is general. For example, this court can take evidence in a suitable case, in a suit.
Straight suit.
The other way of looking at it is the proceeding in which the document is produced, whether he has by law authority to receive evidence. There are two interpretations. So if it in the latter case, in a section 11, it is not the practice nor is it the law that you actually take evidence. Then how would section 33 apply?
May I just
wanted to.
May I just place it? This word evidence, if we look at the definition under the Evidence Act, it would mean examination in chief, cross-examination, re-examination again. But we are now dealing with a section 11 application where the document, the instrument itself is evidence. Because your arbitration agreement is contained in the document, the instrument itself. So the court is receiving the instrument in evidence or as evidence of an arbitration agreement.
One more thing. There, see, we read that three categories. Every person having law authority to receive or by consent of parties authority to receive, and every person in charge of a public office. Then, once it is produced, the satisfaction should be only on one thing. That is, if it appears to him that such instrument is not duly stamped, then the word shall used therein, it is having its own importance.
Yes.
Because once it is produced and this is the satisfaction, then it is not sufficiently stamped. Then the word shall import.
I'm grateful. Would your lordship just have volume 3?
Therefore, that shall import means they have no other option but they should.
I'm grateful. Just have volume 3.
Is it the constraint in which it should be construed?
Yes, your lordships have held so. Volume. Your lordships may come straight away because the judgment is Government of Andhra Pradesh versus Sri Lakshmi Devi. I'm relying at para 16, page 104.
And we no dispute about it. They are bound to. I mean, the section is very clear.
Very clear.
I mean,
there is no distinction.
Doesn't require any judgment. It's bound
Just
to.
in case.
Shall impound.
Though
the purpose of stamp duty, though the purpose of stamp duty is fundamentally to see that revenue is being collected. That, that we also see to it. The document which is unstamped. At the time, particularly when the Stamp Act was introduced, it was a very important source of revenue. Documents.
May I just say this? It took a judgment of your lordships and sewage lamps to kill this process of transferring immovable property by power of attorney, will, affidavits. The law was already very clear.
Absolutely.
It was very clear. But it took a judgment of your lordships to put an end to all this.
Sewage lamp.
Sewage lamps.
Yes.
That you will not transfer immovable property by this method. Sale deed and a duty. Registered document. Law was always very clear.
Revenue, they should be
ला तो चल रहा है टेबल और बढ़ाओ तो
one time. But at the same time, you have to harmonize. Then there should be no revenue loss at one time. Then the arbitration should also go on.
Certainly, Manoj.
ऑन कर
And by the time it's finally culmination into an arbitration award,
Yes, ma'am.
whatever the revenue is required over the document in question,
पावर में कर देते
stamp duty. That period also must be consumed and the document must be duly stamped. If you put something a rider in between, that no, sorry, you can't proceed. Everything has to be stalled
No.
unless you do it first.
Manoj, may I
Then the system is not become workable. We want to harmonize
Efficiency.
efficiency
come to the Stamp Act. I will show Manoj
and to make the system workable. And what is happening is,
Manoj.
under this legal jugglery, we are putting everything in a corner where the system is not working.
In fact, Manoj, the parties themselves are responsible.
न्यूजीलैंड के लिए हफ्ते
That's why they are here.
कि आपकी ड्रीम 11 तैयार है
That's why they are here. But we
Let me
want
put
to
it very clearly. I'll take your lordships to a Stamp Act.
you see, you argue your case first. To whom you are representing. Okay, you argue it first. And then as an officer, you go to provide the system as Mr. Gaurav Banerjee has done.
Yes.
How to streamline,
Yes.
अगर
taking the ground reality over there, and to see that the system made within the four corners of law, workable and effective. And there should be no delay. And no revenue loss at the same time. Because otherwise there will be revenue loss, which should not be there.
Ultimately, because all this money goes to see a consolidated fund.
That's correct.
It is our benefit, our infrastructure.
So we have to examine totality.
Suppose that is protected, the realization of the stamp duty is protected. We are asking you to suggest us a methodology whereby the efficiency of the arbitration process is protected, as is the objective of the amendment and bringing the ancestral.
I'm sorry
Yes.
to interrupt, my lord. May I say this, my lord? Your lordships are putting to my learned friend and impliedly
To you
putting
also.
to me that in the guise of adopting ancestral, we should not blindly ignore some provision that is in the statute. That was something which was bothering my lords. My lord, I mentioned that, my lord, I have circulated a note. I'm sorry I did not read it out on 35 to my lords on the 19th, which, my lord, which explains 33, 33.2 and 35. My lord, if your lordships have a look at that, perhaps this, my lord, bogey that the appointing authority must do this on day one, my lord, that seems to be the burden of the song, may not be, my lord, strictly correct. Your lordships will have a look at this. My lord, I have also.
We are looking back actually. That while entering into the contract, it should have been stamped. Not that the authority at the first instance.
My lord, while entering into the contract, it should have been stamped, my lord. But the short answer to that is, while entering into the contract, it need not be stamped if you don't have to go to court, because all the obligations, rights and obligations are valid, my lord, and they are to be executed.
You don't have to go to court, then you escape scrutiny by any authority.
So, my lord,
But your obligation to
the obligation to pay, my lord, is captured when you come before an authority. That's right, my lord.
no, obligation comes when you are entering into the contract. The scrutiny as to whether that obligation has been
Well, not
discharged
there.
or not, that you can escape if you don't come to an authority.
My lord, may I put it differently? The stage at which I enter into the contract, my lord, there is no dispute regarding the validity of that document or that transaction. That's not the intention of the Stamp Act. No, the Stamp Act does not void that transaction.
Mr. Banerjee, perhaps you would benefit by looking at your 5-page note.
Yes, my lord,
because you omitted to present it.
I omitted to
But
present,
now
therefore, my lord,
all
this
time
entire
is being spent.
Yes,
So
yes.
perhaps
My lord, if
we
I can
proceed-
place this note,
we
because
just have Mr. Banerjee.
my lord, I have addressed this very question.
Yes.
What my lord said, my lord. In fact, your lordship's example makes me, my lord, it has to be a little, maybe slightly tweaked. But my lord, I would submit that this covers the situation.
Let us have a look at this.
No, this was circulated.
This one.
This one underneath it. This is.
4-5 page.
It will be inside. It might be inside.
And your lordships will have the act, the Stamp Act.
Not that.
Is given sir.
लेकिन ये भी नहीं आया कि यहाँ पर प्रेजेंट छोटी बात कर रहे हो कभी नेगेटिव नहीं होती आप मुझे कोई फाइंडिंग आई है कि वो आप
Just see. Get a copy. Just you have to back in the earlier. I'm so sorry. Give me a sec.
Mr. Banerjee, you continue.
My lord, first page is section 11.6a circumscribes the scope of authority of the appointing authority. My lord, that my lord, I have already placed that your lordships will not see. Please see section B, section 33 of the. Which one?
You got no.
Got it. My lord, we've got one.
You got one.
इधर दे दी.
Another one?
Yes, we can.
No.
उससे आपको 2 नहीं दीजिए अभी.
No, this is in the light of Justice Roy's example, my lord, of a standalone agreement and a agreement which has substantive, my lord, rights and obligations. In that light, please read. Stamp Act is a general provision which is a fiscal measure attracted by an instrument. Section 33(1) is titled Examination and Impounding of Instruments. So, my lord, examination necessarily must precede any impounding. Necessarily before an impounding agreement, the judicial authority, which includes an arbitrator, has to examine the instrument under 33(2) of the Stamp Act. So, your lordships will keep 33(1) and 33(2) together. Would your lordship just look at 33(1) and 33(2) along with this to understand this argument? 33(1) says every person having by law consent of parties. You know, that one aspect, whether it covers a Section 11 case. Authority to receive evidence. Every person in charge of public office except an officer of police before any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions. Your lordship will pause here. Shall do what? If it appears to him that such instrument is not duly stamped, impound the same. So, my lord, he must impound the same, but it must be preceded by an examination that the instrument is not duly stamped. Now, please see 33(2). For that purpose, my lord, for the purpose of examination, every such person shall examine every instrument so chargeable and not so produced coming before in order to ascertain what is the scope of his examination, whether it is stamped with the stamp of the value and description required by the law in force in India when such instrument was executed or first executed. So, my lord, this is the examination he has to carry out. Now, please come to paragraph 4 of the note. If this examination is to be carried out by an appointing authority under 11(6)(a), that authority will not only have to determine whether the arbitration agreement duly stamped or not, he'll also have to determine whether the instrument which would include the substantive agreement is required to be duly stamped, because the entire agreement will have to be seen. Inquiry would necessarily involve the appointing authority adjudicating upon the substantive rights and obligations in the instruments apart from determining who is liable for what amount. So, my lord, practically he will have to look at the entire document to determine and examine what is the stamp duty. Now, my lord, that I would respectfully submit that the 33(2) examination necessarily be wider in scope than the limited examination of existence of arbitration agreement enjoined by 11(6)(a). So, my lord, my submission is that please see 33(2). 33(2) is prior to impounding. If you have to impound, you have to look at the entirety of the document. My lord, I am only one caveat following from Justice Roy's, my lord, example. Supposing it is just an arbitration agreement, which is 2 pages, my lord. Actually, frankly, my lord, no such document comes on record because that's 5,500 rupees. So that will be, my lord, it will not really arise. Every document which you are now going to impound will require a wide-ranging examination. And that wide-ranging examination will not be limited to, my lord, 11(6)(a) is confined. That's the first word. Examination, same word in, my lord, 6(a) and 33(2). Existence, which we are debating, my lord, what existence mean? I don't want to interrupt, my lord, I have something to say, of the arbitration agreement. So, my lord,
Mr. Banerjee, why are you saying the scope of examination would have to be widened?
For this reason, my lord.
Because
the scope
at the 11(6) stage,
right,
court will look only on the basis of the presumption that there are 2 agreements, not presumption, that is the fact. There's one agreement for execution of contract or whatever, the other is for arbitration. For 11(6), court will have to look at only the existence of arbitration agreement and whether.
But, my lord, at the same time, if we say that the 11(6) court has to examine for the purpose of stamping, the court will then necessarily have to look at arbitration agreement plus substantive agreement. Because the document instrument, my lord, now, my learned friend insists that the instrument is one, my lord. I also concede instrument is one.
You are expanding the scope.
Now, my lord, if the instrument is one, you necessarily, if you have to check whether it is duly stamped or not, which you have to do before you impound. No, no, step 1 is examination. Step 2 is instrument is unduly insufficiently stamped. Step 3 impound. So, my lord, I am saying that step 1 examination in 11.6 will be wider if you are to operate 33.2. And without 33.2, you cannot operate 33.1. Now, my lord, in the balance of the note, if your lordship sees,
The legislature produced the law commission report that
sorry, one.
produced that law commission report which led to 6A.
See, yes, my lord, I have read 5 paragraphs.
That's right. Is it part of the document?
It's, my lord, yes, it is quoted. My lord. It's in the compilation volume
You
4.
wanted to overrule SPBs.
Yes, my lord. I have shown those 7, 8, 10 paragraphs. But here, my lord, in this note, I have quoted, my lord, para 29. Please see para 29. According to me, para 29 in this very note is relevant. The Supreme Court has had occasion to deliberate on scope and nature, so and so. Unfortunately, however, the question before Supreme Court, framed in terms of whether power is judicial or administrative, which obfuscates the real issue underlying such nomenclature as to 1. The scope of such power, i.e., the scope of arguments which a court will consider while deciding whether to appoint an arbitrator or not. Well, Lord, i.e., whether arbitration exists, null and void, whether it's voidable, which of these it should leave for decision of arbitration. So, my lord, the scope of the arguments have been limited. So,
report is in which document?
my lord, volume 4, page 1. We have put in, my lord, the entirety of the report. There are 8 or 12 paragraphs, my lord. In my note, I have mentioned them.
To you also the question that ordinary principle is that the parliament is aware of the existing law.
Right, my lord.
They were aware of the Stamp Act. And what they were trying to get rid of through the insertion of 6A was something different. They have always presumed that
Lord,
Stamp Act is there.
Well, Lord, that's the question.
Unless we say that parliament didn't
Parliament
eclipse the 6A, I mean the Stamp Act.
Well, Lord, I am not saying Parliament has eclipsed the Stamp Act. Well, Lord, I am saying that
postponing it to the.
Yes, I am not saying that. I am only saying that if you want to give, if my lord, the legislative intent is to limit the scope of argument. The phrase used in the parliamentary report, the law commission report, please limit the scope of the argument.
That's right. That is in the context of certain other questions
my lord,
which have been gone into by the court.
My lord, so the question
that Parliament intended that section 33, 35 should become dead letter.
My lord, I am not saying that, my lord. For a moment, I am not saying it becomes a dead letter, my lord. I am only saying that a reasonable and rational reading of 11.6a, 33 and 35 means that this issue of stamping is to be raised before the arbitrator, who is fully empowered. Well, I have got detailed guidelines on that. Your lordships wanted some guidelines.
One question, section 33, otherwise you would agree does apply.
My lord, 33, if dehors 11.6a, my lord.
Authority to, you want that to say, authority to receive evidence.
My lord, I had a look at that. We had also a debate internally about that. We could not find any judgment on, my lord. 11 and authority.
What's your submission otherwise? But for this view which you are canvassing,
my lord,
would it be a case of authority to?
My lord, there is another way of looking at it, my lord. What those judgments, my lord, one of my colleagues will present, my lord, that the Arbitration Act is a complete code, and therefore, my lord, the Stamp Act, to the extent, my lord, that there is any inconsistency, will not, my lord, increase the scope. My lord, there's Kandla judgment, etc. there.
So under section 20 of the earlier Arbitration Act, certainly it was a court and it was authority to receive evidence. It had to be proved. I mean, it had
my lord, under the 1940
Act,
my lord.
What you're asking is, having...
I'll come back on that, my lord. I could not find any case. We also had this debate.
But what is your submission then? Whether otherwise section 33 would apply, because that is the beginning, starting point of all discussion.
My lord, 33, my lord, I would then have to
Mr. Banerjee, can you just put it across in this fashion, just to take it forward, what my brother Justice Joseph is saying? If the power to impound and arrange for levy of the stamp duty is at the stage of the arbiter or the tribunal,
correct,
the objective of the Stamp Act still gets protected.
Is fully,
it doesn't get.
It's fully protected.
So the argument that is being, counter argument that is being advanced, that you are defeating the provisions of the Stamp Act, can always be protected at the stage of the arbitrator
Correct.
also.
That's
I think you can also put it in that fashion.
That's my lord. Insofar as the impact of 33 is concerned, my lord, 33 when it was brought out in 1899, my lord, nobody and the 1899 Arbitration Act, my lord, permitted an oral arbitration also. So, my lord, there was no contempt. It's a general statute, my lord. It's a general statute, and we are now, my lord, treating 11.6a as a full-fledged court, my lord. Our, my lord, problem here is because the word court and high court has been used, my lord, that we are having all these, my lord. The other point I wanted to make, my lord, is court under 2.1e, which is the court which adjudicates matters, my lord. Your lordship will see Section 11, High Court or Supreme Court does not fall within that. So, my lord, it is not a court in the sense of 2.1e, and perhaps, my lord, then if I am pushed to the wall, I will say, my lord, that 33.1 will not trigger. We could not find any case on this, but certainly, my lord, it is not a full-fledged court in the sense
authority to receive evidence.
With
It
that.
not be a court.
It's not, my lord, 2.1e court will be such a court which has authority to receive evidence.
Whether the High Court and Supreme Court acting under Section
11, my lord.
is an authority to receive.
My lord, it is not, it is, my lord, I would say no, my lord, because I would contrast it with 2.1e and say that,
About 2.1e. I mean, don't bring in 2.1e.
my lord, there is a distinction in the act, so I'm only using that to say that.
Of the proceeding under Section 11, would it be render the Supreme Court and the High Court not authorities competent to receive? I told you there are two ways of interpreting it.
Please.
One is Supreme Court.
All, my lord, just because it is the Supreme Court, it is competent to receive.
It has authority to receive evidence. That is one way of looking at it. In the present proceeding under Section 11,
I would say no, but I will get some material to justify that. I would say no, but I will get some material to justify that. I don't want to interrupt, my.
Because when the arbitration agreement is produced as part of the Section 11 petition, is it receiving evidence?
It is not a formal, my lord.
Receiving evidence. This is what, because
it is not formally, my lord, admitting into evidence. It is not a formal admitting into evidence as understood under the
receiving in evidence, admitting in evidence.
Admitting in evidence, my lord.
Receiving is prelude to admitting.
Is a prelude.
Only authority which can receive in evidence can admit it. Section
33
is followed by
right. Admission, my lord, this is not a case where.
Because the predecessor is inbound it, then penalty is paid,
admitted. So, my lord, that stage.
You ordinarily produce it in order 13.
Right. And my lord, that
documents are produced.
And my lord, then 11 also is really in some sense a prima facie finding also. It's not really a determinative final.
Ordinarily in the civil court, when the list of documents are produced, the munshi or the civil judge senior, whoever it is, at the very first stage, he may refer it. He doesn't have to wait till the evidence is
correct.
In a normal civil trial.
No, I'll come back on this and I'll show the guide. There are some guidelines we formulated and reformed. I'll come back on it. No, only this I wanted to point out because I already tendered.
We understood. Let them continue. Yes. Now you have the benefit of listening to him also. You can answer what you have to say by way of his interpretation. That if you have to examine it, subsection 233(2), it is not in an inexorable rule that whenever it is produced, you have to apply your mind and then impound it. You can put it off to the next stage if sort of close your eyes a little bit, and then allow it to pass muster. Look whether it exists both in law and on facts. One way of looking at it.
Only postponing.
The examination is wider.
Saying that get through quickly Section 7 because the 30 days my brother says could also be present in our mind.
You're just postponing the operation most. Postponing 33 and 35 to the arbitrator.
That's it.
May I endeavor to place the Stamp Act, perhaps to show that it is not such a complicated adjudication which is sought to be done. I will not repeat notes section 2, section 3. I will show section 17. First,
Nobody is saying there's no scope of adjudication. It has to be. Because once we are of the unanimity, okay, to what others may say, that has to be stamped. So the ruling out this judgment before us says no, not to be stamped. And global. We prima facie have our own reservation about it. So if it has to be stamped,
has to be.
then that's stage over. Now the only thing is this examination which has to be made over the document in question as to whether it is adequately stamped or insufficiently stamped or unstamped. At what stage? That is the only question. If it is pre-reference, the thing is 6A. If post-reference, this task will be taken care of by the arbitrator and the party to proceed. That is the only examination. So 33 is the examination, subsection 2, the examination and then impounding of the state. If not stamped, then 35 is there. We are asking you, you are saying no, presuppose first no. The very threshold, you have to hold this examination and a scrutiny to the document and to be adequately stamped by a collector or by own, whatever you do it, and then proceed. This is what to say.
This is what I want to say this much. To understand this much, let us examine first how the Stamp Act goes about adjudication and stamping. How fast is the mechanism if you really want to be fast?
Oh, you can't educate all our officers there.
No, I'm not on that. May I request your lordship to see the Stamp Act? Few sections to show the working of the Stamp Act. But nothing stalls. If you don't want it to stall, nothing stalls. Fast is the mechanism. Nothing. Please have section 17.
Educate all our officers there.
What is the trigger? Section 17, Stamp Act.
Trigger, you raise an objection, the trigger there. Any party who all requested for arbitration, raise an objection and the trigger comes.
Trigger for the purpose of stamping. Section 17.
Vice President.
Instruments executed in India. All instruments chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Now, if we see the definition of execution, it is signature. That is section 2, subsection 12. Simple signature. So at the time or before, you have to pay stamp duty. 18. If it is outside India, then the 1 month becomes 3 months after it is received in India. So before or at the time. Now please have section 27. What are the contents?
Yes.
Facts affecting duty to be set forth in instrument. The consideration, if any, and all other facts and circumstances affecting the chargeability of any instrument with duty or the amount of the duty with which it is chargeable shall be fully and truly set forth therein. Then please have 29. Who pays duty? In absence of an agreement to the contrary, the expense of providing proper stamp shall be borne. The lordships may have A, then if a person executes, then B. If a person takes a contract, then B, A, B, C, D are there. So liability also is fixed. Your payment, time of payment, your person who is responsible, then please have 31. Where an instrument, from mark these words, words, whether executed or not. So even before you've signed it, you can send a draft. And whether previously stamped or not is brought to the collector, and the person bringing it applies to have the opinion of that officer as to the duty, if any, with which it is chargeable, and pays a fee of such amount not exceeding 5 rupees and not less than 59 paise, as the collector may in each case direct. The collector shall determine the duty, if any, with which, in his judgment, the instrument is chargeable. So
14 also. 14 also. Because only one instrument to be on the same stamping.
Yes, I'm so
if you are
single document.
that the arbitration agreement, it is another, and the other thing, it is separate. That is not permissible in view of. What is to be looked into is the instrument. Please, whether it is relevant, just 14.
That's 49. Only one instrument to be on same stamp. No second instrument chargeable with duty shall be written upon a piece of stamped paper upon which an instrument chargeable with duty has already been written, provided that nothing in this section shall prevent any endorsement which is duly stamped or is not chargeable with duty being made upon any instrument for the purpose of transferring any right created or evidence thereby, or of acknowledging the receipt of any money or goods, the payment or delivery of which is secured thereby. Coming back to section 31. So even before you execute, you sign the document, you can send it to the collector for opinion. Now, on getting it, what does the collector do? For this purpose, the collector may require to be furnished with an abstract of the instrument and also with such affidavit or other evidence as he may deem necessary to prove that all the facts and circumstances affecting the chargeability of the instrument with duty or the amount of the duty which it is chargeable are fully and truly set forth therein, and may refuse to proceed upon such application until such abstract and evidence has been furnished accordingly. Even before
We are not examining the very scheme of the Act of Stamp Act. We are on a very limited issue.
May I submit this?
Come back to the issue in question to us as to what, whether pre or post, and why pre.
The issue what I can guess. It is a time consuming. It takes time.
Time consuming something different.
And it will require.
Let's go into practical aspect.
11.6a means, that's what I'm saying. The instrument, the Stamp Act provides stages at which who is to pay, what is to pay. Schedule has, if this is the document, this is the amount. That is what it is, adjudication. This is the document per schedule, this is the stamp duty. Simple. Who is responsible to pay? 29 will apply. You are not sure if stamp duty is payable is correct, please take a draft to the collector. Once he endorses it, pay stamp duty, use it. There is no bar. 32 minutes also, once it is done, the bar, there is no bar. The endorsement works. It is all that has been provided to you. If you fail to do it, then 33 comes in. Therefore, I'm to say that it would consume time, which in my respectful submission, you had an opportunity in section 17, even before signing it, you can take an opinion of the collector. That can be done. You don't do it. You don't pay or pay it insufficient. And then when the bar starts applying a 33 and because you tender it in a court of law, then can you say that the purpose of 11.6a would be defeated? You had opportunities. And this is not all. Please have page section 44. Person A is responsible, person B pays. He can collect it, make it part of his claim. Person paying duty or penalty may recover the same in certain cases. When any duty or penalty has been paid under section 35, section 37, section 40, 41 by any person in respect of an instrument and by agreement or under the provisions of section 29 or any other enactment in force at the time when such instrument was executed, such other person was bound to bear the expense of providing the proper stamp of such instrument. The first mentioned person shall be entitled to recover from such person the amount of stamp, the amount of duty or penalty so paid. Skip 2. Such amount may, if the court thinks fit, be included in any order as to costs in any suit or proceeding to which such persons are parties and in which such instrument has been tendered in evidence. If the court does not include the amount in such order, no further proceeding for recovery of the amount shall be maintained. Now see 45. Power of revenue authority to refund penalty or excess duty in certain cases. Where any penalty is paid under section 35 or section 40, the chief revenue controlling authority may, upon application in writing made within 1 year from the date of payment, refund such penalty wholly or in part. Then 2 also, refund of stamp duty. Now please have the educated mechanism.
One moment, perhaps something. You have a scheme framed under section 11, right? So kindly look at the appointment of arbitrators by the Chief Justice of India scheme 1996. That is still available?
Yes.
Still relevant? Can we see what is the nature of the proceeding and what is to accompany and what is the scheme? What does the scheme provide for? Is there? It is there. Let's see. There's the page 65. This is to be followed, isn't it? You take it that this is still relevant.
Yes, ma'am.
Kindly go through it. This is only 2 pages.
Yes, ma'am.
What is the
Sub request 2.
so this is a request to the Chief Justice. No, of course, it has been found to be a judicial proceeding, not administrative. But so it starts with a request, and let's see the very first thing that is to accompany the request.
The request to the Chief Justice under subsection 4 or 5 or 6 of section 11 shall be made in writing and shall be accompanied by A. The original arbitration agreement or a duly certified copy thereof. The names and addresses of the parties to the arbitration agreement, the names and addresses of the arbitrators, if any, already appointed, the name and address of the person or institution, if any, to whom or by which any function has been entrusted by the parties to the arbitration agreement under the appointment procedure agreed upon by them, the qualifications required, if any, of the arbitrators by the agreement of the parties, a brief written statement describing the general nature of dispute and the points at issue, the remedy, the relief or remedy sought, and an affidavit supported by relevant document to the effect that the condition to be satisfied under subsection 4, 5 or 6 of section 11, as the case may be, before making the request to the Chief Justice has been satisfied. And 5 additional servants.
And then it says rejection of request under section 6.
6.
Where
Sorry. Where the request made by any party does not fulfill the requirements of para 2 of this scheme, the Chief Justice or the person or the institution designated by him may reject it.
Yes. So this is a statutory scheme framed under the Act. We are just again interlinking it with the first sentence of section 33.
Person receiving evidence.
Evidence. Because it is H, section 2H speaks about an affidavit supported by the relevant document to the effect that the condition under section 4 and 5 has been satisfied. So let us have a look at section 4,
11,
4 and 5.
4, 5 are those provisions. Affidavit has to say that I have not followed the procedure. That's the limited portion of the affidavit. It's not.
So this document, what you are again straining to come back to, this document, is it being received in evidence?
It is being received as evidence of an arbitration agreement or appointment of an arbitrator. Otherwise, because there is no point in filing this
Because
document.
you will see one more thing. You can either produce the original
And the certified copy.
or a certified copy. Okay.
The original will have to be stamped. The certified copy also will have to be stamped.
Supposing the certified copy is produced and it is let into evidence under section 36.
Because 36 supposes that it has already come into evidence. It has already been acted upon. Then 36 comes.
Supposing it is let into evidence without any objection and the court not looking into it. Will it then be evidence? And can you still say that you will not act upon it?
There are judgments which are based if the lordship wants.
So no, once it is let into evidence, though it is not stamped or insufficiently stamped, can the court refuse at the end of the day when the judgment is pronounced to not treat it as evidence and say we will not act
Because your
upon it?
foundation is missing.
No. Once it is let into evidence, the law says that forget about the fact that it is not stamped. Then it becomes evidence.
It becomes evidence.
Then you cannot say we will ignore it.
Which 36 provides once it is admitted, then such admission shall not, unless 61 shall be called into question. That is the question. Now,
61-2. 61-2.
plus before
61-2.
Oh, yes. 61.
Instrument should not have been admitted in evidence without
Yes.
payment of duty. Then what should be? A declaration.
If such instrument, if such court, after such consideration is of the opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty under section 36 or without the payment of a higher duty and penalty than those paid, it may record a declaration to that effect and determine the amount of duty with which such instrument is chargeable and may require any person in whose possession of power such instrument is, to produce the same and may impound the same when produced. And this is given to a higher court.
Yes.
And this is done on application of either suo motu or on application of the collector. 61.1 says, please, 61.1. When any court in exercise of its civil or revenue jurisdiction or any criminal court in any proceeding under Chapter 12 or Chapter 26 of the CRPC 1898 makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp or upon payment of duty and penalty under Section 35, the court to which appeal lies from or references are made by such first pension court may, of its own motion, or on the application of the collector, take such order into consideration. Then 2 applies.
Yes.
Now, Chapter 6, first is the control of the Chief Revenue Controlling Authority. If the collector has any doubts, he can refer it to the Chief Revenue. If he has any doubt, statement of case to the Honorable High Court.
Yeah.
So a very systematic procedure has been laid down. Then, beloveds, may I invite your Lordship's attention to certain stamp acts of 3 foreign countries. The bar of Section 35 is also there in the stamp acts of these foreign countries. And those are arbitration heavens, allegedly. Let's just have the first, your Lordships may take volume 3, Convenience Compilation 3, page 260. This is belongs to UK Stamp Act. Lordships may have page 261. Convenience Compilation 3, page 261, UK Stamp Act. Please have page 261, bottom, section 14.
Spending average.
Convenience Compilation 3 by Apple.
This is Gaurav Banerjee. The other one.
Mr. Goel.
ये वाला नहीं, Goel का.
Mr. Goel.
Spending.
Volume 3 of Mr. Goel.
This is Roy.
Yeah, I'm with you. But what is the purpose of showing us the stamp act of UK?
I will show stamp acts of 3 countries, which have a similar provision. And this includes UK, Singapore, Malaysia. Terms upon which instruments not duly stamped may be received in evidence. Upon the production of an instrument chargeable with any duty, as evidenced in any court of civil judicature in any part of the United Kingdom, or before any arbitrator or referee, notice shall be taken by the judge, arbitrator, or referee of any omission or insufficiency of the stamp thereon, and the instrument may, on payment to the officer of the court, whose duty it is to read the instrument, or to the arbitrator or referee, of the amount of the unpaid duty and any interest or penalty payable on stamping the same, and of a further sum of £1 be received in evidence, saving all just exceptions on other grounds. So this is proviso A, 35. Now just have 4. Save as aforesaid, an instrument executed in any part of the United Kingdom or relating wheresoever executed to any property situate or to any matter or thing done or to be done in any part of the United Kingdom shall not, except in criminal proceedings, be given in evidence or be available for any purpose whatever, unless it is duly stamped in accordance with the law in force at the time when it was executed. Then we'll also have Singapore. The next page, 264. Relevant section, Milots, is 268. At page 268, section 51 and 52, identical to our sections. 268, section 51 top. Every person having by law or consent of the parties authority to receive evidence, and every public officer or officer of a statutory body before whom any instrument chargeable in his or her opinion with duty is produced or comes in the performance of his or her functions must, if it appears to him or her that such instrument is not duly stamped, impound the same. For the purpose of such subsection 1, every such person must examine every instrument so chargeable and so produced or coming before the person in order to ascertain whether it is stamped with a stamp of the value and description required by the laws in force in Singapore when such instrument was executed or first executed. Then 3, it does not apply to large police officer and so and so. Just have 52 again. Subject to this section, an instrument chargeable with duty must not be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, and must not be acted upon, registered or authenticated by any such person or by any police officer unless the instrument is duly stamped. Singapore. Now you'll also have Malaysia. These are all the 3 arbitration heavens. Same Stamp Act provisions impounding paid duty. 272. This is the Malaysia law. 51. Every person having by law consent of parties authority to receive evidence, and every person in charge of a public office, except an officer of police, before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions shall, if it appears to him that such instrument is not duly stamped, impound the same. Then 52, again, no instrument chargeable with duty shall.
We are not examining the constitutional validity of any provision of the Stamp Act here. We are not examining.
Yes.
So the comparison of other countries, Stamp Act not required. Our Stamp Act is very clear. There is no doubt of ambiguity there. We only examining in totality what should be a stage where the trigger of stamping should be taken care of in the mechanism for arbitration of it.
Section of duty. That
Yes.
can be done at-
Keeping the revenue, there should be no revenue loss. Where the trigger should come. So the term confined to examine the arbitration agreement under
Existence.
Existence.
Section 8.
No, in section 6A, subsection 6A.
6A.
Existence of an arbitration agreement. Confined to examine the existence of an arbitration agreement. That is the term.
Let us fall back to the state.
Now the only thing is what we are dilating on the issue is whether this trigger of unstamped or insufficient stamped is to be looked into at this stage, or it has to be
left to the arbitrator.
post reference stage.
In fact, that your lordships have already answered. It applies to every authority, load, and the legislative scheme doesn't cut it across. It applies to the court, it applies to the arbitrators. So if we read this section as it stands, please, 33, 35, I have shown from the provisions of the Stamp Act that a person, an applicant who is relying on an arbitration agreement for the purpose of section 8, 9, 11, he has had ample amount of opportunity to pay stamp duty.
And one thing more.
1. 2.
Once you are enclosing this agreement at the pre-reference stage, is it document or an evidence?
It is the instrument was given as an evidence of an arbitration agreement. It is an evidence because under section 8, you are asking the Honorable Court to act upon the arbitration
Agreement is in the form of a document on the
It
court.
is in writing.
Maybe writing. Document is always in writing.
Yes,
But whether it is an evidence,
it is an evidence of an arbitration agreement. You are receiving the document as an evidence of an arbitration agreement. Let's A under section 8, refer the parties, section 9 for interim relief, section 11 below 6A to appoint an arbitrator. Let's, you cannot, in my deepest, in my respectful submission, let's, you file a document before the court saying in section 8, 9, 11 that this is the arbitration agreement between us. What is the party doing? Is it not relying on the instrument, the document, as evidence of its contention that there is an arbitration agreement? Or the inquiry under 6A, if we put it this way, is it limited to only saying whether it is printed or not? Is this the inquiry contemplated? Then why have?
It must be signed by the parties. There must be a clause of arbitration. Prima facie, the arbitral dispute must be within the parameters in the corners of the agreement.
Public policy also. Some disputes will not be arbitrable.
And pre 6A, it was a judicial orders.
Yes, limitation also used to be.
That's correct. But post 6A, would it be judicial order?
Submission, it would be a judicial order.
Tell us.
It would be a
Pre 6A, obviously, Constitution says judicial order. Post 6A is the judicial order. Once your jurisdiction is makes so limited within the brackets, is it a judicial order?
Fine.
If a judicial order, you have to master all conditions, preconditions, which have been confined in 6A. So whether the 6, you see, my judgment, which I was the author earlier, to ruled, my view that time was only this, that as long as the court, which he said, to change the mindset, is exercising the power as a judicial exercise of power, then it must have. But after 6A, the scope has been limited down. It's coming to an extent only to examine, confine the agreement and proceed further, so that the time schedule, as legislation wisdom thought, must be confined and go ahead. If we again go back to 6 system, pre-6A, then we are restoring back the same view earlier.
Right, I understand. 6A minutes, the Law Commission's report your Lordships have seen, only 3 judgments. The SBP and Bogara. Only they were dealt with. Had stamping been a part of the contemplation of the legislature, it would have said SMST also. SMST, legislature.
That we have some reserve. Merely because the Law Commission's report has not referred a judgment, that doesn't mean that the judgment stands.
Let us examine it.
They take totality of the view in expressing themselves by they asking for amendment. But merely because one judgment of this court
is not referred to
even unnoticed or even unnoticed, it can't give an impression that no, the judgment still holds. You have to examine the statutory amendment made in the light of whatever the observation.
We are now going back to the pre-SBP that it is only an administrative power. Just look at it, close your eyes, and then send it to the arbitrator. Then it gets stalled before the arbitrator because of the stamp act.
You can't be look at it and close your eyes. You will be opening your eyes, look at it, and then thereafter.
That's what I'm saying. You close your eyes to the illegality.
No.
This is not impounding, cannot happen.
Illegality.
Can't be done.
If recovery is possible at a deferred stage, then you are not defeating the stamp act. We must be conscious at all time of that particular possibility. At the time of scrutiny under 11, yes, you look into whether it exists or not. So far as recovery of stamp duty is concerned, that is possible even at the deferred stage, that you can't run away from. So you have to look at it with open eye and maybe also be conscious that with this open eye, am I also keeping in mind that recovery of stamp duty would be possible at a deferred stage?
It's therefore this. I'm repeating.
If the judge under 11.6 is told that the arbitration agreement exists, can that question be revisited in section 16?
That has been dealt with and then said prima facie existence is there, and then the final call would be taken by the arbitrator. That
No. Let's get that straight. Come to paragraph 12 of SBP and then read paragraph 33 of the Law Commission report. Let's understand it.
My Lord may see the judgment of Justice Nariman on this point.
That's right. No, we'll see that. But
where he
before
says
that-
prima facie existence, and then existence will go in trial, my lord, before the arbitrator. I'll just existence, my lord, specifically. That's that.
No, just the
Para.
you read page 644 brother, of this 2005 SEC, the SPP person.
No, because section 16.6 take note of
Existence. My lord,
Yes.
that was the real reason for, my lord, the amendment. That was the real reason.
That
Not
was
more-
yeah, if you if you just read
No, that is the majority.
paragraph 12 at page 644.
Because I'll
No,
read-
that is the majority view which has now not been accepted.
Let us see. Let us go step by step. Just
Oh,
say
well,
that page 644 of SPP.
दुकान तो गलम मन आदमी
If we are pleased,
Yeah.
आदमी का ना काम में
section
लिखे
16 of the Act.
Just a minute.
It is to overrule that it has been done. What part of it has been overruled? We have to
पहला ही नहीं
Just show that
पर 11 बच्चे हैं
paragraph
12,
12 at
643.
page 644.
644.
And towards the end of the
हाँ तो इनका सब बतियाला तो ना होला पर ही पर
just say from D, Basicum D,
है वाव के
It also
also
appears to us.
appears to us.
It also appears to us to be.
It also appears to us.
It also appears to us to be incongruous. I'm so sorry.
Yeah.
It also appears to us
करे तो गलम
incongruous
मछली
to say
काने
that
तो गलम
after the
मछली
Chief
मरवा
Justice had appointed an arbitral tribunal, the arbitral tribunal can turn around and say that the Chief Justice had no jurisdictional authority to appoint the tribunal. The
मरा
very
गला है।
creature brought into existence by the exercise of power
कितना
by
हाल
its
है?
creator, the Chief Justice. The argument of the learned senior counsel, Mr. K.K. Venugopal, that section